In the recent court case of Carson v. Macon, there was a question of does a state law prohibiting students participating in an available student aid program and using this aid to attend religious schools violate the practice of free speech and religion? To guarantee that every student in the state of Maine has access to free education, the state of Maine relies on local school administration units. Many do not run their own public secondary schools. Without the availability of public schools in this Maine area, there are some families which are not able to afford the public schools without student aid. Without a public secondary school of its own, the SAU may either enter into a contract with another to offer access to its students, or pay the tuition of a secondary school that accepts particular students in order to satisfy state criteria. Any secondary school must be either a state school or a private school that has been approved in some way. Private schools must comply with the state's mandatory attendance laws in order to be considered a approved institution. This can be proven by receiving certification from the New England Association of Schools and Colleges or by the Maine Department of Education. This case overall has very much of an important aspect due to the right of free education. Well gave importance over the act of not excluding families who are using assistance to send their children to private schools due to it being the only school available to them in the area of residence, and reinforce the value of federalism and limited government. The United States v. Lopez case is significant. The scope of federal authority, the allegation of federal between the federal government and the states, and the interpretation of the Constitution have all been significantly impacted by this decision.